around the analysis of some case law that he has done. And before he comes up, I looked at the Blue Ribbon report that Cindy talks about in her book, and an analysis was done in 2000 where they looked at the fraud occurrences on some corporates. So they wanted to check the correlation on companies where there was fraud, whether there was an existence of an audit committee, and even how those audit committees were constituted. It was interesting that one of the researchers, Bisley, in one of his summaries, evaluated that, or rather concluded that the existence and the composition and the activity, there wasn't always correlation. However, what he then said was that it's clear that most audit committees were just ineffective. So it wasn't because there was no audit committee, but his conclusion back then was that it's because these audit committees were ineffective. We'd like to hear then what Prof is going to tell us around some case studies that he's looked at. Prof.
Thank you. Can everybody hear me? Can everybody hear me now? Yes. Good afternoon, ladies and gentlemen. Before we start, I need to read and quote from the latest literature, the ACE model. And you'll see I have a quote from a judge which says you must refer in carrying out your duties to the latest literature. Areas of literacy, the ACE model says, I must judge for myself, but how can I judge? How can any man judge, and I presume woman too, unless his mind has been opened and enlarged by reading? I'd like you to just keep in mind that word reading. And the model goes on to define financial literacy, which does not mean having expert knowledge on financial issues, and I'm going to take you through some court cases of that. And something I found very, very important in the context of what I'm going to say today is this model has defined auditing literacy. And auditing literacy can be summed up as the ability to understand what your assurance providers or auditors are telling you. Now, I can tell you now, there are many, many court cases, and what I'm going to say to you today is about the audit committee not listening to their assurance providers. But before we get there, I just want to, where's my, there it is. That is, we spent a whole day talking about lists and checklists, etc. And here you have the audit committee, I think, snoozing around the table. And it says, that's the last box ticked. Has anyone anything further to raise? Guys, it was so important what someone said this morning about not ticking boxes. Because by ticking boxes, you are not complying with your fiduciary duties. You're not taking care, you're not having skill, and you're not being diligent. The tick boxes are there to remind you of what you've got to do. And what we're going to look at today is about not ticking the boxes, about what the lawyers, I hope there are any lawyers here before I have my lawyer jokes. Okay. It's about not ticking the boxes and about making up your own mind about what John Adams said. So let's have a look at the first case. Now, this is a case we have heard of many times before. It's ASIC versus Healy. Healy was the chairman of the company. Notice the name of the case is the chairman of the company. But the company was called Centro. And someone asked earlier on if you give those financial statements to someone the night before. That's not the question. You've got to give them to them at least 2 weeks before. Because you've got to, and you'll see what the judge says about that. Now, the review of the annual financial statements is in King, that they have to comply with. King says you must review the financial statements, but it's a delegated statutory duty in terms of the Companies Act. It's not the ones listed, but it says right at the end, in section 94, it says, the directors, the board can delegate anything to the audit committee. And once that's done, that becomes a statutory duty. Now, what did the directors say? And bear in mind, the ACE model talked about reading, very, very important about reading. And this is what Justice Middleton said. He said, all directors must carefully read and understand financial statements before they form their opinions on those financial statements. Now, such a reading and understanding would require the director to consider whether the financial statements were consistent with his or her own knowledge. And you have to have a knowledge of the business before you understand accounting. You'll be pleasantly surprised that if you understand the business, how easy accounting can become, not only for the accountants, but for those non-accountants. And in this case, what happened in this case, the audit committee, the board, everybody got it wrong. They didn't know the difference between short-term and long-term liabilities. How can you say that an auditor, how can you say that a director, even CAs, didn't know the difference? Well, they didn't know the difference for their industry. And short-term, long-term is not necessarily 12 months or more. It's in terms of your operating cycle. So each industry has an operating cycle. So if you do not know your business, you can see how easy it is to get it wrong. And it says, a reading of the financial statement by the directors is not merely undertaken for the purposes of correcting typographical or grammatical errors. Well, maybe that should suggest the balance sheet doesn't have to balance. The reading of the financial statements by Director, Justice Middleton says, is for a higher and more important purpose: to ensure as far as possible and reasonable that the information included therein is accurate. Ladies and gentlemen, the people, even if you're an engineer, even if you're an architect, you have to understand the content of the financial statements. However, no one expects the engineer or the architect, and even the chartered accountant for that matter, to understand complex derivatives. But at least you have to understand the basic accounting conventions, and we'll get to that. The scrutiny by the directors involves understanding their content. The director should then bring the information known or available to him or her in the normal discharge of their duties to focus. So in other words, you have to understand that business. Now, it says here, let's go to the last one. It says, therefore, I do consider that all that was required by the directors in this case, in this proceeding, was the financial literacy to understand basic accounting conventions and proper diligence in reading the financial statements. All they had to know was the difference between an asset and a liability, income and expenses, short-term, long-term, not in the context of IFRS, but in the context of their own business. And if they understood it within their own business, they would have got the accounting right. And that was the difference. There's another court case in New Zealand in 2010 where a judge said IFRS is complex. Even the auditors have technical experts today. And the reason the directors are standing in court today, by the way, is because the experts got it wrong. So the question is, can you find a director guilty of negligence even if the experts got it wrong? So the judge let them off. However, that was a case of complexity. This was a case of blatancy. Short-term, long-term, they should have got it. So all the directors have to know is basic accounting conventions. Now, what we're going to do is to get into an auditing literacy case. As the ACE model talks about auditing literacy. This is it took place in 1996. So, by the way, in 1996, we didn't have Cadbury, we didn't have King, we didn't have all these type of reports, because I think the first King report came around about 97, 98. So, what happened here? William C. Connor, Senior District Court Judge. Now, I must explain something to you in American law. There were no judgments, because this goes to a jury. So, you've got a jury of your peers, people who aren't accountants, people who aren't auditors. They found the audit committee guilty, because that's what they would have expected the audit committee to do at that stage. In this case, it was found that the audit committee had not adequately consulted the company's internal auditors. There wasn't a King report to tell them they had to, but you know what they had in their charter? They had in their charter that it was their company policy to consult the internal auditors. And you know what the law says? They take the higher, the most onerous. So if the law says nothing or the law says something, and your policy is more onerous, the law will go for the more onerous. As a result, there were continuing issues concerning the adequacy of the internal audit process. The court held that the audit committee's failure to act on the internal audit matter, plus the fact that it had been made aware of dubious accounting practices, meant the committee was willfully blind to fraud going on around it. They did nothing. They were guilty by omission. And that's what they were found guilty on by a jury. They should have consulted their auditors, internal auditors. And in other words, a lot of clients, a lot of audit committees are allowed to rely on their auditors. They get a draft audit opinion, and they are allowed to take that into account. They still must have independent judgment, but what the judge said, if you're going to abdicate your fiduciary duties, you have no right to rely on someone else. The new CEO uncovered numerous alleged accounting irregularities, and the write-offs wiped them out. A very familiar situation. And what was it alleged in this case? It was alleged that the audit committee were aware of the dubious accounting practices, and they should have investigated them. What was the evidence led in this case? Each year, a letter stated that some improvement had been made by the audit committee. But the external auditors each year recommended further strengthening of the internal audit function. So they said they needed to improve it more. Nevertheless, the audit committee did not become actively involved in improving the internal audit process. And had they done that, they might have uncovered the fraud. So what the jury was saying, well, you said you had to have an internal audit committee, internal auditor, but you didn't. And had you did that, you might have found the frauds. And in fact, the internal auditor didn't even attend the audit committee meetings. And the audit committee defendants did not read the reports. So in other words, there was no king, as I said, there weren't no corporate governance, but this is what lay people thought, that you have to comply with certain types of expectations. And the expectation in 1996 was that you listen to your internal auditors and you listen to your advisors. Otherwise, you could be seen to be reckless. There's another case in 2002. By the way, the cases are just getting closer and closer. We'll soon, 2015, 2016, hopefully not on audit committees. Failing to investigate. So what happened here? The case revolved around the audit committee's failure to deal with certain matters raised by the external auditor. So the previous case, there wasn't even an internal auditor. Now there was one, and they didn't seem to listen. Although the external auditor had given an unqualified opinion. And that was raised a lot today. If you give an unqualified opinion, what else should you be reporting in the auditor's report? The auditor made recommendations about internal controls concerning revenue recognition, cash collections, and outstanding receivables. The court considered that the audit committee had been put on notice. The fact is that the auditors read and gave a report at the audit committee meeting. They had been put on notice, but had done nothing to investigate them, nor had it received specific assurances from either the auditor or management that the problems were being resolved. So in other words, they should have engaged their auditors to find out how things were being improved. Now, it was alleged by the defendants. So the defendants were sued, and this is what they alleged, that the company had failed to implement a system of internal audit controls as external auditors had been persistently recommending them. We kept on telling you what to do, audit committee, but you never seemed to listen. And they failed also to hire an internal auditor. Can you imagine? They failed to hire an internal auditor, and obviously what I'm reading from this is that if an internal auditor is like an internal control. So in a large public company, if you don't have these internal controls like the internal auditor, you're bound to make mistakes. Because most audit committee members are non-executive, independent, and they're not part of the day-to-day running of the business. So who else can they rely on? And not only that, the management were issuing financial information in the press without approval of the audit committee. So the audit committee somehow allowed people to make statements in the press. And from this, I haven't heard it discussed before, but the audit committee must worry about what's being said in the press. So could this be the fact that whoever is going to release things in the press, maybe sponsors, etc., maybe they should run it past the audit committee first. And in those audit committees that I've been on or that I advise, that usually is the case. So, ladies and gentlemen, what can we learn? Well, there are 3 lessons which we can learn. Failure by the audit committee to have or acquire a sufficient level of financial literacy or familiarity with the company's affairs may itself amount to a breach of Section 76 of the Companies Act or common law fiduciary duties. Audit committees cannot substitute reliance upon the advice of others. So the audit committee cannot sit there and say, wow, look at the draft auditor's report, looks great. Okay? For their own attention and examination. Audit committees cannot ignore the advice of those persons who are their appointed advisors. They just simply cannot, unless it's obviously unreasonable. And courts have and will in the future ensure that the audit committee do the job the law and the public want them to do. So when, God forbid, a director is taken to task, it's not going to only be about what it says in the Companies Act or the PFMA or the MFMA. It's going to be about what the public expect of you. And that is going to be the spirit of the law. Sometimes is more important than the actual part of the law. In fact, that's how they do it in this country. Look at the purpose of interpretation, the objective of the law. So, guys, from what we see is that the audit committee must listen to their advisors. That's why we have all these reports, the internal auditor's report, the technical report, the litigation report, and all these hundreds of reports. Unfortunately or fortunately, however you wish to look at it, the audit committee sits as the pivotal role in the company. It is in the public's best interest. Countries all over the world have seen it. It's public policy to have an audit committee, and the audit committee sits there as a statutory body appointed by the shareholders, and that's how important it is. Thank you.
Don't go away. I guess after that presentation, audit committee members who are here will probably like to unpack and ask some questions, but indeed it indicates that this is a serious responsibility and must indeed be discharged with care. But again, don't forget, the ACE model is there to help you. If you haven't got a copy, 350 Rand outside before you leave. Any questions? Has the Prof scared you?
Simply something to think about.
Okay, certainly. It's something to think about, and the importance, again, is understanding your responsibility when you accept certain audit committees. It was mentioned earlier, here's a question, that the importance of managing the number of audit committees that we sit in to make sure that we are also very effective. But most importantly, the risk, assessing the risk at the clients, just because of the nature, the leadership, and other industry issues pertaining to that client, it is very important. The responsibilities are really quite high.
Thank you, Program Director. My name is Ndombi. I'm just wondering, after this scary presentation, where does that insurance issue factors in? The insurance and the board issue, whether does that help us in any way?
Okay, so the Companies Act, this wasn't so in the previous Companies Act of 73, but in the Companies Act of 2008, there is a provision for the company to pay for your insurance. But that insurance will only apply in times of simple negligence, not in terms of gross negligence or fraud. So it would depend on the result of the court case or the damages, etc., on whether the insurance will pay out or not. But it is new in the Companies Act that the company can pay for your professional indemnity insurance. But the professional indemnity insurance will be under instruction not to pay it out if you have been found guilty of gross negligence, as opposed to, you know what, I did everything in my power, and the business judgment rule, and I did everything okay, but it just turned out to be a bad decision at the end of the day. That they will pay for. But this type of thing, I'm not sure that they will pay for. Here's a question.
Okay, Vusi, I won't ignore your hand this time, so please ask the question.
Thanks. My name is Vosim Sibi from the Auditor General. I just want to find out what are the common drivers where basically audit committees tend not to meet their obligations, because it's either risk management limits are basically looked away. If you look at corporate failures, you do have risk limits that are basically ignored for the sake of making profits, you know. One speaker made reference earlier on to appointment of audit committees, because I have no doubt that the level of literacy, expertise, it's at the right level. But why would you have the entire committee ignoring these, basic responsibilities, so to speak?
Hopefully that's not going to happen in the future. But at the end of the day, first of all, the regulations to the Companies Act make specific reference that a third of your audit committee, how they do that, I'm not so sure, because if there are 3 people on the audit committee, I presume one each must have a special skill. And it goes on to human resources, social, business, accounting, and so there is a law that says you have to have special skills. So when a board or shareholders appoint the audit committee, they should be taking this into account. They are under a legal obligation to appoint people in terms of the regulations to the Companies Act. And the regulations to the Companies Act say you have to have these skills. So I'd be so bold as to suggest that those shareholders that appoint audit committees that don't appoint those people with the right skills are in breach of their duties and would be subject to Section 2182 of the Companies Act, where it says anyone who is in breach of the Act can be sued for. So, for example, I'm just thinking of it now, is that Section 2182 is, let's say the shareholders appoint an audit committee without the skills, and something, God forbid, goes wrong, and the company suffers a lot of damages and loss of money. Those shareholders who appointed that audit committee are in breach of the Act, if it obviously can be proven. And that should be the disincentive for appointing people that don't have skills on the audit committee. But the drivers behind, most of all, are, number one, financial statements, is the complexity of financial statements. You should have experts, not maybe on the audit committee, because people are on the audit committee are not experts in complex financial instruments. But if the audit committee feel that they need to get hold of experts, they must do so. In fact, the Companies Act says so. It says that the company will pay for it even, in law. So I know there's a lack of skills and we have that issue. But at the end of the day, no one should be appointing individuals to audit committees without the necessary skills, because it does create liability. And the courts are just going to look to see, they're going to look to see, have you got the people with the skills, yes or no, and your liability will be done on that. But then again, all technical reports, there are so many technical reports that come through the audit committee. Unfortunately, those guys on the audit committee are going to have to spend some time liaising with management, but not liaising with management too much. Audit committees can't liaise with management too much, because then you don't want them to be involved in the day-to-day operations of the business. That fine line, I'm not a lawyer, I wouldn't know. But at the end of the day, it's a problem. And I presume as we go along, we will find ways to deal with this. But the issue is, what makes people fear and not do anything is the fear of they don't have the knowledge. So I can only, but in the Centro case, you wouldn't believe it, that on the audit committee were CAs, were lawyers, and they also failed to do anything. So I'm going to turn your question around. What would make people do something? Well, these guys on the audit committee at the Centro, there were lawyers and CAs. Those lawyers are not practicing anymore, and nor the CAs. They've all been struck off their respective roles for doing what they did. So usually it's fear of the unknown, and people without, you need the skills. But, a person doesn't have to have the skill at the time they get appointed to the audit committee. They must make sure that they have those skills over a period of time. And where they're building up those skills, they must just take advice. No one said you have to do it on your own. You can get advice. So what makes a person abdicate their responsibilities? I only did psychology 1 at varsity, so that's as far as I can explain it.
That will be our last question for this session.
Thank you. I am from the Eastern Cape, and I'm saying this in the context of what the Prof said. If I'm taking it in the public sector's context, because I know sometimes the King Code may not be applicable 100% in the public sector, and we need to acknowledge that. But the legislation that we have in the public sector in terms of appointment of the audit committees, I like to repeat that. If I'm in the Eastern Cape, I'm a councillor in the Nyanden district municipality, and I'm a teacher by profession. What would I know about audit committees and all that? And I have to make a decision in the appointment process of the members of the audit committee. I'm saying this in the context that a lot of councillors, I will take Gauteng out, do not have even the minimum requirement metric. Now, how do they make a decision in terms of appointing finance literate people when they don't even have the metric? What would you recommend in that aspect?
Sure, who's going to help me answer that one?
I don't think there's anyone.
I understand. I'm not sure of the answer. And that's why I say we're going to have to develop these skills over time. And there is a case to be made that if anything does go wrong, and by the way, I know it's not the PFMA or the MFMA, but the Companies Act, and there's a common law principle in this country of what skill, care, and diligence means. I'm not exactly sure we can apply it, but you're going to look at the way you conducted your duties with your knowledge, skill, and experience. And if it could be proven that you should have known. So in other words, if you do not have the education required, I don't believe it's going to stand against you, because it's about conducting your duties with your skill. And that's a mixture of what they call an objective and subjective test. In Australia, for example, it's just total reasonable person. So it would be, here we don't have that reasonable person test 100%. It's reasonable with your knowledge and skills. So I think our Companies Act and our law take care of certain situations like that. And at the end, I just wanted to point out something. You said something. You asked me my favorite question, by the way, does King apply to public sector? Well, it does. You know how? Did you heard of a case, Dali and Porfu versus SABC? Well, what happened in that case? Her Ladyship Justice Victor said the following: I know that King doesn't apply to public sector, but I'm going to make it. And so she judged that whole scenario based on King 2. And according to Professor Delcourt and according to Professor Duplessis, a lot of these profs have written now that no matter whether you're a small private company, whether you are a public sector company, your conduct as a director will be measured against the 3 King reports. That's now, it's going to be, judges say that it's not a legal, by the way, it's not a legal document, but it will be measured. It will give the judge an idea of what's going on. That's about it.
Thank you very much, Prof. And Zolisa earlier indicated that they are aware of those challenges, especially in the municipalities, and there is capacity building and training that is taking place from a National Treasury point of view. So they said just give them time, it is being looked at.
So can I just add one thing to that? We can only do what we can do. We can do the best we can. You can't start appointing, if we've got no skills, we've got no skills. You can't just manufacture them out of thin air. So we're going to have to put people on committees that don't have the skills. How else are you going to get the experience? It's like the tender. You know, when you apply for a tender and they say you need the experience, well, if they don't give you the work, how are you going to get the experience?
Okay, Prof, I think